Hi, and welcome back to this intellectual property class. In today's class, we're going to be talking about patent infringement. So in previous classes, we've talked about the formal and substantive requirements for patentability. Today, what we're going to discuss what happens when somebody's accused of patent infringement and how to go about practically determining whether or not infringement has actually occurred. The Patent Act provides that infringement occurs whenever somebody without authority makes, uses, offers to sell, or sells any patented invention within the United States or imports into the United States any patented invention during the term of the patent. That's infringement. Okay, so if any one of those requirements are satisfied, then infringement has occurred. That's making, using, offering to sell, selling, or importing a good that embodies the patented claim, a good or practice that embodies the patented claim in question. Okay, well, there's multiple kinds of infringement as well, right? So we can have direct infringement. That's where you bring a patent infringement action against the person who's actually doing the infringing themselves. In other words, are they the person producing the infringing product, importing the infringing product, selling the infringing product, etc.? Or you can bring an infringement action based on indirect infringement. In other words, the enablement of somebody else to infringe the patent in question. We'll try to distinguish between the two. Okay, so how do we determine whether direct infringement has occurred? Well, first thing we do, as we've discussed in previous classes, is we construct the claims of the patent in question in order to determine what the patent actually covers, right? In other words, that's why the Markman hearing, that's why claim construction is so important. We first have to determine what the property right conveyed by the patent actually is. We have to determine what the subject matter of the patent in question is. And then you compare the patented claim, you compare the construed claim to the product in question and determine whether the product satisfies all limitations of the claim. In other words, are all of the elements of the claim present in the accused product? Okay, that's how you determine direct infringement. In order to determine indirect infringement, you have to determine whether the defendant induces or enables a third party to directly infringe. So there always has to be some direct infringement, right? It's just in an indirect infringement action, you say you're making it possible for someone to infringe, even though you aren't directly infringing yourself. In other words, for example, if you make a product that enables a third party to infringe a patent claim, right, then your product isn't per se a direct infringing product, right? It doesn't satisfy all the claims of the patent itself, but the infringement is realized by the third party and you made that possible. Therefore, you're an indirect infringer by virtue of enabling that infringement. So we'll talk a little bit in the discussion about why we might want to provide for both direct and indirect infringement liability. Okay, so what are the defenses to infringement action? We're going to talk about those more in our next class. But there's three primary defenses. First being that, well, the product in question doesn't actually satisfy all the limitations of the patent. In other words, the claim doesn't read onto the accused patent. It doesn't actually infringe. Something's missing, right? One of the limitations isn't met, right? Therefore, infringement hasn't actually occurred, right? The second would be, well, I have a license, right? You can't bring a patent infringement action against me if I have permission, right? If I'm allowed to do it, then it's not an infringing action. And then finally, the defendant can assert that the patent claim is invalid. In other words, the patent claim shouldn't have issued in the first place and therefore can't be infringed because it's not a valid patent. Okay, three possible defenses. Okay, so let's talk about the Nassau Precision Casting v. Acushnet case. What happened here? So Nassau owns a patent number 5,486,000 on a weighted golf club head, right? Or more specifically, a golf club head in which the weight of the golf club head is placed in particular locations on the golf club head. And there's two claims at issue, two patent claims at issue in this case, right? What's the problem? Nassau is asserting that the Acushnet company is manufacturing clubs that infringe on its patent claims, which broadly speaking, we're going to get into the language more specifically, but broadly speaking, the patent claims in question state that material is taken from one part of the golf club head, namely the top of the golf club head, and moved to another part of the golf club head. And that doesn't minimize its ability to strike the ball. And by moving the weight, you end up imparting more force to the ball and enable it to be struck more effectively. Okay. So we've got two different claims, which the Federal Circuit interprets slightly differently. So the district court below finds that neither one of these claims were infringed, right? The Federal Circuit says that the second claim was definitely not infringed, but the first claim possibly was infringed. And it depends on the construction of the claim and the facts about the product in question. So we can start with the second claim, right? A method of improving the weight distribution of a selected construction material constituting a golf iron club head, right? And we use when a patent uses the term constituting, it means that these and only these limitations are present. And you'll note that the first claim uses the term comprising, I believe. Well, anyway, so we can see the term constituting is used here, and the Federal Circuit looks at the club in question and says this is not infringed because in the accused club there's material replaced, right? And that material replaced weighs something, right? Therefore, it's not all taken from one place to another place. It's actually replaced with another material. Therefore, it's materially different from the patent claim, and the claim doesn't read onto the product in question. The first claim is a little bit more difficult, though, right? Because it depends on how the claim is actually read, right? And there's multiple interpretations on how to read the claim. And effectively what the Federal Circuit says, look, if we read claim one broadly, then the club is at least potentially infringing. So what we need to do is, determine what the appropriate reading of the claim is in relation to the club. We don't have the facts available to do that. We need to send that back to the lower court. And interestingly, it says, look, Nassau's made claims about what the coverage of the patent claim is, right? And they ought to be held to the interpretation of their patent claim that they've made below. In other words, if they want the patent claim to include as broad of a construction as they suggested, right, where it would mean removal of material from any part of the club, including part of the club face, then they have to be held to that interpretation of the claim by the lower court. And the problem with that is it expands the scope of the claim in question, right? But at the same time, it also makes it more vulnerable to potential invalidation by prior art. Right. So essentially, what the court's saying is you can't have your cake and eat it too. Right. You can't interpret the claim more broadly when it's convenient and then interpret it more narrowly when it's convenient as well. You're stuck to the same interpretation regardless. Okay. Now, what happens in a circumstance where the patent claims don't precisely read onto the product in question? Well, it's literal infringement is when we have every element of the patent claim present in the accused product. Non-literal infringement occurs when it's close, right? It's essentially the same as the patented claim, but there's a non-material difference between the two, right? And that's where the doctrine of equivalence, which we've discussed earlier, comes in. Essentially, what it says is that so long as any differences between the patent claim and the product are not material differences, they're equivalent to each other, then it'll still be an infringing product. And that's essentially designed to prevent people from kind of doing an end run around a patent, as it were, by simply changing something that doesn't matter, right? And sort of looking at the patent document, practicing the patent document, right? But making a twist such that it's not exactly the same in an effort to avoid being infringers. And the concern is that allowing people to do that would essentially vitiate the meaningfulness of getting a patent in the first place. In other words, we don't want people to make trivial or meaningless changes and thereby avoid patent liability. Okay, well, so the Doctrine of Equivalence was first adopted by the Supreme Court in Winans v. Denmead. And so this was a patent on a railroad car shaped like the frustum of a cone. That's a section of a cone. So it's basically a round railroad car with a flat bottom. And the defendant created a octagon-shaped railroad car, also with sloping sides. And when the patent owner sued, the defendant said, well, you claimed a cone, we made an octagon. Those aren't the same thing, therefore we're not infringing. And the court said, no, that is infringing, even though the patent claims a cone and the the accused product is in the shape of an octagon. They're practically speaking equivalent, right? They do the same thing, and it's a non-material difference between the patented claim and the product. Therefore, the doctrine of equivalence says that because it's functionally equivalent to the patented claim, it can still be infringing, even though it doesn't literally infringe the patent in question. And the court has reaffirmed the doctrine of equivalence on several occasions. The question is how broadly the doctrine of equivalence should be read, right? Because, as the court and others have observed, right, if you have no doctrine of equivalence, well, then it's going to be too easy for people to sort of avoid infringing a patent just by doing something non-materially different. But if you make the doctrine of equivalence too broad, then in effect you're allowing patent owners to claim outside the scope of what they've actually patented, and it kind of defeats the purpose of having patent claims in the first place, right? I mean, the idea behind having patent claims is that you're telling the entire world what you're claiming ownership over and what they have to license if they want to practice it, right? If you make the doctrine of equivalence too broad, well, then people won't know what a patent actually covers, right? They'll have to sort of guess and check, and you're going to have situations where people find themselves innocent infringers, not realizing that when they read the patent, it didn't cover just what it said, but it also covered a bunch of additional material that wasn't present within the scope of the patent document itself, right? So kind of thinking about how to structure the doctrine of equivalence such that it doesn't extend too far is a real problem. As a practical matter, right, courts are wary about pushing the doctrine of equivalence, right? They want patents to be confined to the scope of the patent language, right? So making a doctrine of equivalence argument is always a bit of a risk and a gamble. Okay, so how do we go about determining whether the modern doctrine of equivalence ought to apply, right? Well, essentially you look at the alleged equivalent accused product and say, is the change insubstantial, right? What the courts have adopted was known as a function way result test. Essentially the idea is it accomplishing the same thing in the same way? Right? Is it essentially doing the same thing without a substantial difference between the two? If so, then perhaps it's a equivalent and non-literally infringing. Okay, there are also certain legal limitations, right? That are restrictions that prevent the doctrine of equivalence from applying. One of the probably the most important is known as prosecution history estoppel. In other words, the courts should look back to the history of patent prosecution, the process of obtaining the patent in the first place, and determine whether or not the alleged equivalent was originally included within the patent claim and then removed for the purpose of obtaining the patent, right? In other words, if the patent applicant had originally tried to claim the equivalent and then they took the equivalent out, well, that's pretty good evidence that they're not entitled to own the equivalent that they're claiming. Maybe it isn't really an equivalent at all. Maybe the equivalent was covered by prior art and therefore not something that the patent owners were entitled to. Maybe they didn't disclose the equivalent, right? And the defendants have now done something meaningfully different, such that the product shouldn't be deemed infringing. In other words, if they didn't disclose or enable the alleged equivalent, well, then are they entitled to claim the alleged equivalent, right? Maybe it's beyond the scope of what they were actually entitled to patent in the first place. In addition, the all limitations claim vitiation rule says that all limitations of the claim have to be satisfied, and the disclosure dedication rule says that if you disclose something in a patent document without claiming it, then whatever you've disclosed without claiming is dedicated to the public domain. And we'll talk about all of those more in a moment. Okay, so what happened in the Festo v. Shoketsu Kinzoku Kogyo Kabushiki company case? Well, here we have a problem where the patent claims a product, the allegedly infringing product, the accused product, is very similar but has meaningful differences. And the question is whether those meaningful differences are insubstantial, such that the doctrine of equivalence ought to apply, right? And so we have to kind of go through those different limitations in order to determine whether that is appropriate. What essentially the Festo Corporation has two patents here over a improved magnetic rodless cylinder, right? So basically it's like a piston-driven device that relies on magnets to move objects in a conveying system. It's like a mechanical piston device. Okay. Now, there were multiple amendments of the patent application during the patent prosecution process. And so the better part of this case is really asking about whether those amendments prevent Festo from making a doctrine of equivalence claim under the circumstances. And essentially, both of the amended patents added a new limitation that the inventions contain a pair of sealing rings, each having a lip on one side, which would prevent impurities from getting into the piston assembly. In other words, the sealing rings prevent dirt from getting into the device, which would make it not work properly. And in addition, there was a limitation. One of the patents included a limitation that the outer shell of the device had to be made of a magnetizable material. Okay, so Festo starts selling its product based on these patents it's obtained, and SMC, which is the acronym we'll use for Shoketsu, starts manufacturing a really similar device, right? However, there's some differences, right? Rather than using two one-way sealing rings, it uses a single sealing ring with a two-way lip, right? So the sealing rings are accomplishing the same thing, but they're constructed differently and work differently. Moreover, the sleeve of the SMC cylinder is made out of a non-magnetizable alloy, right? So there's another limitation that isn't covered, right? So it's very clear that SMC cylinder doesn't fall within the scope of the literal claims of any of Festo's patents, but Festo says, no, it's still non-literally infringing because it's an equivalent of the device claimed in our patents, right? It's so similar that it infringes anyway. The lower court, the federal circuit, finds that no, the doctrine of equivalence doesn't apply. Why is that? Right? Well, it looks to the prosecution history and says, look, these changes were made in the patent document in order to obtain the patent in the first place, right? And if you made changes to the patent document, right, if you added an additional limitation relating to the sealing rings, relating to the nature of the material that the casing is going to be made out of, right? Well, then those changes are going to be hard limits on the scope of your patent claim, right? Those were changes made in order for the patent to issue, and therefore, if the accused product doesn't if the patent if those claims don't read onto the accused product, then the accused product can't be infringing because you had to include those limitations in order to get the patent in the first place. In other words, those were necessary in order for the patent to issue. The Supreme Court says, and essentially the Federal Circuit kind of adopts a blanket rule and says, look, if you've amended the patent in order to receive, if you amended the patent application in order to receive the patent, then those additional limitations have to be included in the accused product in order for it to be infringing. And the Supreme Court says, well, maybe if it was because of prior art, right? If it was for novelty concerns, okay, right? Under those circumstances, it's very clear that those limitations are going to be absolutely required. They're going to be necessary, and we can see a hard limit based on those. But what if you amended the patent claim for the purpose of satisfying the 112 disclosure and enablement requirement? Well, under those circumstances, it's possible that you just didn't anticipate what the alternative equivalent approaches would be, right? And so maybe under a 112 amendment, based on making sure that the patent claims meet the disclosure and enablement requirements, you could show the possibility that it's actually equivalent for various reasons, right? So you could essentially rebut the idea that the amendment would create estoppel to assertion of a doctrine of equivalence claim, right? So one way you might do that is to say, look, we amended because of disclosure and enablement, but this new technology wasn't foreseeable at the time, right? So we couldn't have known that people would do it this way, even though it turns out that it's actually equivalent. So essentially what it's saying is like, look, if there's existing technology that already does this thing, well, then you probably should have known and considered that in making the amendment. But if it's a new technology that came along after the patent was prosecuted, well, then maybe you couldn't have foreseen that, and it shouldn't come as a surprise that you didn't write it into the patent document itself. Therefore, it might at least potentially still be an equivalent, right? In addition, if it's just tangential, right? I mean, the patent document can't include everything, right? If this is a tangential element or a tangential a point, then maybe you can show like, look, it's one more in a long list of things that could have been included. We included them, we could, but we couldn't get everything in there, and it's still equivalent. The difference is non-material because it's sort of related to but tangential to the kind of the main thrust of the patent document itself. And then there's just the kind of the kind of a more kind of catch-all, kind of some other reason why it wasn't included. You kind of got to think of that narrowly, but the idea is like, look, words can't capture everything, and therefore we shouldn't be overly technical about what the patent document actually states. We should think about what the patent document means. Now, this is a little questionable, right? Again, it's like, we want to be fair to patent owners by saying we're not going to construe your patent so narrowly that it's really easy to avoid and you effectively won't be able to assert it. But at the same time, if we're going to have patent documents claiming in words, right, the words have to mean something, right? And so on some level, we need to hold the patent documents to the words they actually use, rather than enabling or allowing patent owners to sort of claim outside the scope of what they've actually stated. Okay, so under the all limitation rule, or the claim vitiation doctrine, we, in addition, say that every claim is material, and therefore the doctrine of equivalence have to be applied to individual elements of the claim, not to the invention as a whole, right? In other words, you can't just say it's basically the same invention, right? You have to point to each individual element of a claim in order to determine whether the allegedly immaterial difference is equivalent or not, right? It can't just be, well, the whole invention is essentially equivalent. It has to be in relation to the particular parts of the patented claim. And we can think about that, broadly speaking, in relation to the Cadence Pharmaceutical v. Exela PharmSci case. What happened here, right? Well, there's a patent on a method for obtaining stable acetaminophen formulations by deoxygenating solutions with an inert gas to achieve oxygen concentrations below 2 parts per million. And essentially what it comes down to is the patent claims a particular method of obtaining these formulations where the oxygenation occurs. So Cadence essentially says add the active ingredient and then deoxygenate, but Exela deoxygenates first and then adds the active ingredient, right? So this is an element of the patent claim, right? The Cadence patent says do it one way. The Exela process does it the opposite way. And Cadence says, hey, you're infringing. You're practicing the invention that we've patented. Exela says, no, we're not, right? I mean, your patent literally explicitly claims doing the adding the active ingredient, then deoxygenating. We're deoxygenating first and then adding the active ingredient. Those aren't just different, they're the opposite, right? How can we be infringing under the circumstances given that your patent literally claims one thing and we're actually doing the opposite thing? Cadence says, well, no, those are equivalent. It doesn't matter what order you do them in. And they bring in experts to testify to the effect that the order of adding the active ingredient and deoxygenating are irrelevant to the realization of the product. Therefore, the Federal Circuit says, yes, under this, because it's not relevant, because it's immaterial what order you do them in, it is indeed the equivalent and therefore and infringing of the patent claim. Now, seems like a bit of a problem, right? I mean, it is the opposite, but as we can see, you look to the particular element, and because it doesn't matter, because it's proven as a factual matter that it's irrelevant what order it happens in, the two processes can be equivalent, and therefore it's still an infringing use. Now, you might think about how you might go about drafting the patent claim in such a way that it covered both, right? Rather than, explicitly putting those two processes in a particular order, right? I mean, if the order doesn't matter, surely the patent claim could be redrafted such that you could capture both within the scope of the claim and not have to litigate under the Doctrine of Equivalents. I mean, after all, it would be far better to be able to show literal infringement rather than have to prove non-literal infringement. And then finally, we can talk about the disclosure dedication rule, right? As might be obvious, right? The Doctrine of Equivalents creates a kind of perverse incentive for patent applicants to disclose really broadly, right? And then claim really narrowly, because then you can just say, well, look, I mean, you didn't literally infringe the patent claim, but it's not a literal infringement. I can prove it by pointing to the disclosure and saying, look, these were all the things that we talked about in the disclosure. You're doing those things. Therefore, it's effectively equivalent as shown in the disclosure itself. Well, the disclosure dedication rule prevents that kind of gaming of the patent system by saying, if you disclose it in the patent, but you don't claim it, everything disclosed but not claimed is dedicated to the public. It's in the public domain. By doing that, by disclosing without claiming, you've disclaimed, as it were, any ability to assert ownership under the doctrine of equivalence of that disclosed invention or discovery. So